Welcome to everyone, and let's take a look at family and the legal system, LS508. This is a very interesting course, and it's a quite diverse course as well. It has to do with family relationships, but also legally, it has to do with contracts, prenuptial agreements, postnuptial agreements, separation agreements, parenting plans if there are children involved, and also financial aspects of family law are covered here as well, such as alimony and child support. And so also it's impossible to talk about everything related to the subject in one course, but the course is extremely important because basics can be covered in sufficient detail to enable you to learn a great deal. You would want to look at fundamentals of marriage laws to begin with. A little background for a moment may be useful. The 13 original colonies were already populated in the early 1600s. Harvard University, for example, has been having continuous school years since 1636. That's 140 years before the United States was the United States. So in the original 13 colonies, you had people getting married, getting divorced, and all these kinds of family law issues were rising even before the United States was the United States. So when the 13 colonies unified themselves and became the United States, they already had family law systems in place. They had divorce grounds, they had judges in place who heard family law cases. And so those systems have been historically the province of state law. You don't go to federal court, for example, to get a divorce. That's done on the state level in the state where you are. And so it's important to look at some of these fundamentals of marriage laws because as the states became states, part of the United States, on the state level, they passed different grounds for divorce in the different states. Now, until 1970, divorce in the United States was fault-based. You had to pretty well prove someone else did something to break up the marriage, like the other spouse. But in 1970, California adopted no-fault divorce, and this eventually spread across the entire country. So now if one party to a marriage wants a divorce, they're going to get the divorce. There were times in Georgia where a friend of mine practiced 30 years ago where they had jury divorce trials. Now, can you imagine having a week-long trial and a panel of jurors determining if you should have a divorce or not? Well, we've kind of gotten past all that in family law. So now it's not unusual for a family law judge to have 20 or 30 cases on the docket for one morning in court and go through all of those, granting with each a divorce decree, because no longer is it necessary to prove that the other party, the spouse, did something to actually break up the marriage. We have no fault divorce, so you can get a divorce without having to prove anybody did anything worthy of fault. So the law has changed greatly in this arena in the last several years. Also, as people now many times are more prosperous, we see more prenuptial agreements, especially when there is a wealth disparity between the two people who are getting married, because the wealthier spouse often wants to protect themselves so that if the marriage does break up, they don't lose a lot of money in the situation. Need to mention also that 9 states and only 9 follow community property law. 41 do not. And the 9 states that do are mainly in the central and western part of the country. If you live in the eastern time zone, you do not live in a community property state. None of the states in that time zone follow community property. The states that are the most easterly in the country that do follow community property are Louisiana and Wisconsin. And so the other 7 are west of those geographically. So if you've always lived in one of the original 13 states, you don't live in community property land. You live in equitable distribution land, as it's called. So prenups are helpful and useful, especially when you have a wealth disparity between the parties or in situations where the parties have been married to other people before and are already bringing significant assets into the new marriage. Also, with children involved, matters are much more complicated, especially if children are involved and the couple is divorcing when the children are young, because there are issues of education, there are issues of child support, all sorts of issues have to be dealt with. Medical decisions have to be made as children grow up, and all the things that your parents would have done if you grew up in a household with both parents there would have to be done then with some cooperation between the parties as children are growing up. So we'll look at custody and child support agreements. I live in a state where we have a rule in the state code. It's called Rule 32, and it has charts in it where it's very easy to compute the child support that is due. You take the person's income on one column, the other column has how many children they have to support, and it gives you a number. Some states have a more complex way to address this issue or give judges a lot of discretion as to how much child support is actually due. In this course, you'll also draft a divorce agreement and also draft a modified divorce agreement. There are situations where changes occur and where agreements have to be modified. And also, there'll be some teamwork in this course, and you'll be able to actively participate and collaborate with others as you look at this emotionally difficult and often complex area of law. And the states don't agree with a lot of the fine points as to many things related to family law. I live in a state now where common law marriages can no longer be formed, but they were able to be formed until just a few years ago. But the common law marriages were totally created by court decisions. In the state where I live, there was not a statute that created them at all. In fact, the only statute, this is Alabama, in the code about common law marriage is the statute the legislature passed to forbid common law marriages to be formed in this state after a certain date. But there was nothing in there in the code about having them formed to begin with. And it was entirely judge-made law, case law, that allowed for common law marriages to be formed in Alabama. And so this is another lesson that's important to remember here. When you're looking for the law on certain things, certain points, certain subjects, you can't just look at statutes and call it a day, or just look at cases and call it a day. You really have to look at both to get the full picture, because back when common law marriage was permitted in the state where I now live, I'm not from here originally, but where I now live, then if all you did was look in the code at the statutes, you would conclude, oh, well, they don't have common law marriage because it's not in the code. It never was in the code. It was in the case law. So you have to look in both areas, especially with family law, with its very old case law history. But I know you'll enjoy this class. It's got a lot of diversity in it, and it involves emotionally high stakes and personally high stakes as well.